Okay, great. Welcome, everybody. Today we are going to be talking about myths of estate planning and debunking them. We're going to talk about what the common myths are and what really matters and what is actually going on when we talk about estate planning. So before we get started and get into it, a little bit about me. My name is Matthew Rosenthal. My practice focuses on estate planning for both families and business owners, as well as corporate law, but our office also handles probate and real estate as well. I'm licensed to practice in both Florida and New York, and engaged in the community a lot. I'm a member of 4 different chambers of commerce: Lake Nona Chamber, Regional Chamber, the Pride Chamber, the Hispanic Chamber, and the East Orlando Chamber of Commerce. And to varying degrees, I speak a lot for the Lake Nona Chamber of Commerce. I'm a board member in the Pride Chamber, and I participate in events for the Hispanic Chamber in East Orlando as well. To learn more about my history and things like that, please visit our website at rosenthalmeyer.com if you want to learn any additional details and see our practice areas. So before we start, a little legal disclaimer that the presentation is designed to give general information about the topic and does not constitute legal, financial, or accounting advice. And before taking any action, it is recommended that you speak with an attorney, accountant, or an investment professional. And so while we go through this presentation, I'm going to stop after each myth. And if you guys have any questions at that time, I'll take them. And then we'll go through. And then at the end, if you have any questions generally at the end on estate planning or anything we've gone over, please feel free to ask at that time as well. All right, some quick definitions to know as we go through this presentation. When I talk about the word estate, that is what you own at the time of your death. And when we talk about estate plan, it's the blueprint of how you want your financial and personal affairs handled after your death, but it also includes a blueprint of how you want your financial and personal affairs handled should you become incapacitated, but yet you are still alive. Now we're going to get into the first myth for today. Estate planning is only for the wealthy. So some of the most drawn out and contentious cases actually involve the more modest estates that have inadequate estate plans. Why is that? It is because when there is less money to be given out to people, then there's usually more of a fight over who's going to get that money. That's why it's important for everybody to be planning, whether you consider yourself wealthy or not, because everybody has something that they want to give to somebody else, and you want to make sure that it goes to the person that you actually want it to go to. Estate planning is not simply about creating a will. It involves addressing who will make healthcare or financial decisions for you if you become incapacitated. So a lot of people think that when we talk about estate planning, that's creating a will or a trust, and that's it. But that's just the basics of the estate plan. We also want to make sure that you have your advanced directives in place. Advanced directives are things like the power of attorney, healthcare surrogate, living wills, HIPAA authorizations, among other documents that we'll do. For example, if you have minor children, we do guardianship documents. What all these documents make up your estate plan. It's not just one document that makes up your estate plan, but it is all these documents put together. Who will manage your estate is also something that you need to choose. We put that into the will. It's called your personal representative. Here in Florida, some other states might call it executor or executrix. But it's this person that will take your estate through the probate process should that need to happen, or a backup trustee. A trustee is somebody who will manage your trust afterwards. So naming all these people are also part of creating your estate plan. And the value of your assets is not really what's important. What is important is that they are your assets and that you get to decide what happens to them when you're gone. You shouldn't want to leave it up to family members, the court, other people to make a decision on what happens with your assets. They're yours, and it's up to you to decide, should you want to decide who it goes to and who gets to enjoy what you have worked for your entire lives. Does anybody have any questions on this first myth? Okay, we'll move on. Often expressed with the first myth is the second one: I am too young to worry about estate planning. Basically, the myth around this is that I don't have to start planning for my estate until I'm older, till I have children, until I have grandchildren, until I'm in my 50s, my 60s, my 70s. I don't need to do that because I'm young. And the issue with this is that we don't get a warning when it's your time to go. Normally, when it's your time, it just happens, whether you're young or you're old, it does not matter. And so we want to be prepared from the beginning. Every adult, regardless of their age, needs to have an estate plan in place. Life changes rapidly when you're young, and before you know it, you're married, you're expecting your first child, and don't make the mistake of waiting until you have the people to protect to create your inheritance plan. Documents like the will, like trusts, are all amendable, meaning that over time we can make changes to them, addressing all of the changes that happen during your lifetime. So we might start out your estate plan with something much more basic, and then as your family grows, as your assets change, we can increase and add to those plans so that you're fully covered throughout your life. But also keep in mind that part of the estate plan is those power of attorneys, those healthcare surrogates, those documents that help you while you're still alive. That's part of your estate plan too. If you don't have those documents in place, and let's say you get into an accident, is there somebody authorized to make a healthcare decision for you at that point in time? Without the proper documents in place, it can be very difficult to tell who is that person that gets to make those decisions, and potentially there could be court time needed in order to decide who makes that determination. Your last will and testament, for example, may be your only opportunity to let a judge know who you would want to be your child's guardian if one is ever needed. That's something that's important to make sure that's in your will, and so we shouldn't wait until the kids are older before we start deciding, okay, who's going to protect them if something were to happen to me. Is there any questions on this myth? Okay, myth number 3. I have a will, so I'm done with estate planning. Your last will and testament is actually the foundation of your estate plan. However, a comprehensive estate plan typically includes the additional documents that we've been speaking about, such as powers of attorney, healthcare surrogates, living wills, guardianship papers, and we use all these documents to help achieve the goals that you want to set forth. Moreover, if your plan needs to be reviewed and revised on a regular basis, as well as when life events require revision. The typical life events that we would want to review your documents and possibly amend is at the birth of somebody, the death of somebody, the purchase of a large asset, whether that's a home, a second home, or the sale of one. Those type of changes in your life are when we want to revisit your documents and make sure that the documents still work with what just occurred. If you name somebody to be your trustee and you only name one backup trustee to yourself, your trust, and that person passes away, now you have nobody to take over that trust if something were to happen to you. So now we want to revisit the trust and add somebody new into the trust to be your trustee at that point in time when you can no longer be your own trustee. Any questions on this? You can save time and money using do-it-yourself forms from the internet. The takeaway from this slide is that doing things right the first time is always less expensive than doing them wrong and having to fix the mistakes. There are a few issues with the do-it-yourself forms from the internet. Some of these issues are that the reason they are riddled with out-of-state information and also errors. What they do a lot of the times is they are known for creating ambiguities and failing to dispose of your entire estate. One of the issues with doing it yourself forms is that you might not know what you actually need to get done. You are telling a system what the documents that you need, instead of going in and seeing an attorney who will sit down and evaluate and discuss with you and evaluate your assets, your family situation, and the things that you need to put forth, and then create an estate plan that is based on what you need, not what a do-it-yourself form might say everybody could have or everybody needs. These documents are not one size fits all, and we tailor each document to our client's needs. It's also very common for these wills and other documents to be improperly executed. Wills and a lot of these documents require a certain type of signing to occur. For a will to be valid in Florida, it needs 2 witnesses. In order for the will to be self-proving, meaning that you don't need to have the witnesses show up and confirm that they were present at the time of the signing, you also need a notary. And so what typically will happen in these situations is that you will do it yourself on the internet. You'll print these forms and you'll sign the form and you'll put it away. You won't have the witnesses there. You won't have them sign, and therefore your will is invalid. So you've spent whatever you've spent online, but yet the document is not worth the paper it's printed on because it's not signed properly. It also doesn't always dispose of all of the property. It might omit successor designations and what-if scenarios. What if your child passes away before you? What would you like to happen with your assets? What if your spouse passes away before you? What would you like to happen? Did you want to actually prevent the spouse from spending the money in a second marriage? Or did you want to make sure that regardless of how much money you leave to your children, there's always going to be money left for your grandchildren? These are things that we can prepare for when doing estate planning that you don't necessarily get to do with do-it-yourself forms from the internet. Any of these problems could result in litigation during the probate of your estate, and ultimately this costs your loved ones much more time and money than you saved by not working with an experienced estate planning attorney. A lot of the estate planning that can be done could be used to avoid probate. And while probate is not, in our opinion, is not the scary thing that a lot of places make it out to seem, not everybody has to go through it and pay those costs. So if we don't have to, and we can avoid probate ahead of time, then that's a great thing that we can be able to do so that your family members might have access to your assets right away instead of having to wait for the court process to take place. Does anybody have any questions on this myth? Okay. My spouse and I have a joint account, so we don't need estate planning. A lot of times I'll hear from potential clients that we don't need to do any estate planning. Everything that we own is owned jointly. Okay. But what happens when the second one of you passes away or the 2 of you pass away together? Generally speaking, when we do estate plannings for a couple, we do the estate planning preparing for the death of the second couple, second person in the marriage, because in most states, specifically Florida and also New York, we can pass assets very easily between spouses. So the estate plan is not for passing it between you and your spouse. It is for passing it to the next person after the second spouse passes away. Or what happens if you both become incapacitated? Yeah, your names are on the joint accounts together, but now you're both incapacitated. Maybe it's Alzheimer's, maybe it's some other form of dementia, and now nobody has access to these accounts to pay your bills because there was no power of attorney put in place. So these documents prevent and protect you from having issues when something happens. In certain situations, courts may appoint a conservator or a guardian to manage your assets if you are incapacitated or not competent to make financial decisions. The guardianship procedure through court is an expensive procedure and can be avoided with proper powers of attorney and proper healthcare surrogate documents, because those allow people to manage your financial situation and also manage your healthcare. So these documents will help prevent a potential guardianship from ever being needed. A well-crafted estate plan allows you to nominate that conservator or guardian that you might trust. So even though we want to avoid guardianship, if at all possible, we still put a document into place that's called a pre-need guardian designation. Now, this document allows you to choose who you would like to be your guardian should something happen to you. And so you've already chosen that person that you trust instead of leaving it up to chance, leaving it up to family members who might fight over that role. And the costly process of the court can be mitigated by having already made that decision ahead of time. A power of attorney will also allow another person to have access to your financial accounts and matters, essentially helping you pay your bills through your bank, being able to rent out that second home that you might be using as a rental property now that you're not able to do it yourself. Things like that, you can have somebody that you love and you trust assist you in those matters. Any questions on this myth? I don't have anyone to leave my estate to. Why should I be concerned with estate planning? Everybody, for the most part, has heirs, even if you don't know who they are. If you don't have anybody, do you really want to receive that posthumous thank you from the state for your generous gift of your assets? Because then we don't have to do any planning. If you don't have any heirs and we do nothing, eventually, down the line, your entire estate will go to the state. But as an alternative, you may want to consider leaving your estate to a charity, or you could even leave your estate to a friend. It doesn't have to be left just to family members. And good planning of charitable gifts can be rewarding during your life and can provide an ongoing gift after you are gone. So what happens during the process if we don't have any documents in place? This is the Florida Statute 732.103, share to other heirs. Essentially, this statute is put into place for those people that pass away intestate without a will in place to tell us where things are supposed to go. So if you don't have a will put in place or a trust and you didn't name people to inherit from you, Florida will follow this list. To the descendants of you, the decedent is the person who passed, so your descendants first. If there are no descendants, then they go up the line to your father and mother equally or to the survivor of them. If your parents have passed away already, to your brothers and sisters and down their line. If there's nobody, no siblings, or anybody down their line, the estate then gets divided. One half, which shall go to the decedent's paternal, the other half to the decedent's maternal, and then down their grandfather or grandmother's lines. If there's no grandfather or grandmother, to uncles and aunts, and then their descendants, and then just all the way down the line until we get to the state of Florida. If this is not the plan that you want to have done, then we need to do estate planning. Because otherwise, this is the plan that the state of Florida has set out for you. Does anybody have any questions? My favorite myth, I think, is my family will do the right thing. While the hope is that our families will honor our wishes and do the right thing, the best thing that you can do is write them down to mitigate any potential issues. By making your wishes explicitly clear, you can trust that your family will take care of things the way you have wanted. We have these family members, and we all have these children or siblings that you get along, but sometimes when money is involved, things get a little bit more complicated. And so by doing an estate plan and writing things down and protecting your assets and sending them to the people that you want them to be sent to, what we are doing is protecting your assets to go to the right people so that there are no fights between the family. But what you're also doing is you're protecting the family, because family fighting over money can lead to a lot of poor relationships down the line, and sometimes things are not fixable at that point. So if you want to protect your family and make sure that there's no fighting necessary, then we do estate planning to make sure that that can happen. Going along with that, I can make everyone happy. The saying goes that you can please some people some of the time, but you can't please all of the people all the time. And this is especially true for estate planning. You create a will, you divide your assets, you have everything written out exactly the way you want, but still, somebody will always not be happy with what they get. The big takeaway here is just remember that it's your estate. You have worked your life to build these assets, and you need to take care of it and give it out however you see fit. It's not up to other family members to decide how you share your assets with them. They're your assets. You make the decision, and then by putting them in either a will or a trust, those decisions can be followed, and then it goes out to everybody in the way that you want it to go. Somebody might not find that it's fair, but it's fair based on how you wanted it to happen. So an example of this type of situation is maybe you have 3 children, and 2 of them you can trust with money. So we put in your will that 2 of your children get their assets outright, no problem, after you pass away. But that 3rd child is not great with money, spends it every chance that person gets some, it's already gone. So what we decide to do is keep that money in trust for that 3rd family member. And that way, that 3rd family member can get money when they need it, but can't get access to the bulk of the money all at once, and therefore can't waste it all. And it can last as long as possible. I saw a question pop up. Let me see if I can pull that up. Right. Okay. So John asks, are there any laws that certain family relations must get something? So there are some laws in place that protect certain assets. Specifically here in Florida, Homestead is one of those laws that is put into place to protect the primary residence of the house. Most people know of it more on the tax side, and that you get a tax benefit on your homestead property. But there are also estate planning consequences to having a homestead property. If you have a minor child, you cannot give away the homestead away from those minor children. If you were married and you were to pass away, your spouse gets a choice whether or not they take a partial interest in the house with minor children, if there are any, or a life estate in the property. So you can't, disinherit a spouse or minor children as far as the homestead is concerned. As far as your spouse is concerned also, you cannot disinherit them completely. Florida has laws in effect that protect the surviving spouse, and so the surviving spouse is eligible to get at least up to 30% of your estate, regardless of how much you actually want to leave them. So if you didn't want to leave them anything, you can't do that if you are married to the person. I hope that answered your question, John. It's best to appoint someone you trust to fiduciary roles. This is a common mistake, a common myth, and potentially a big mistake. Fiduciary roles in your estate plan, such as personal representative, trustee, or guardian, play critical roles in your plan and comes with a wide variety of duties and responsibilities. The goal here is not just to appoint somebody that you trust, but appoint the person that is also right for the role you are giving them. So for example, in a trust, we name trustees. The trustee might be responsible for running all of the assets that you might have. And there's money and investment accounts, maybe there's stocks. If you are appointing somebody that is really bad at financial management, might have no knowledge of running financial accounts, buying and selling stocks, then that might not be the right person, even though you trust them to be the trustee over your money. However, those people can, though, hire the right people to manage those assets. But if there's a plan that you have in place that you might not want them to go to a financial advisor, you might want them to go and do it on their own. If they don't have the knowledge to do so, then we might not want them to be the person that runs the money. Also, when it comes to deciding who is in charge of the money and then who is in charge of, let's say, your minor children, while you might trust one person to do both, is that the best role for that person? The person that might be best for watching your children might not be the best person to take care of the money, and we can split these roles. We can give the children and make guardian one person and give control over the assets to somebody else who is better able to handle those. So we want to consider what experience and knowledge the roles require before ultimately making the appointment of who is going to be our fiduciary. Let's see. Okay, from Shanti. Can having a power of attorney include health and financial decisions? Is it necessary to have a health care surrogate if you already have designated someone as power of attorney to address healthcare issues? Okay, so there's a misconception between the power of attorney and the healthcare surrogate. The power of attorney is the document that allows somebody to manage your financial and management affairs. The power of attorney actually does not grant, and specifically says it does not grant, healthcare decision-making authority. The healthcare surrogate document is the document where we essentially appoint that healthcare power of attorney or healthcare proxy to make those decisions. So they are two separate documents that we need to put into place to grant power of attorney status and healthcare proxy status. And they don't have to be the same person. They can be, and in many situations they are, but they can be. You might trust somebody more for financial decisions regarding your assets, and somebody else for making healthcare decisions for you. Even if it's, let's say, just your parents. Maybe mom is better at the financial role than dad is, but dad will make a more sensible healthcare decision if something needs to be made for you. So you can split these roles up, so that the right person is holding the right position. Also, as a reminder, for documents like the power of attorney, healthcare surrogate, living will, all of these documents are to protect you while you are still alive. And so at the moment of your death, these documents are no longer valid. That's when your either trust kicks in and takes over, or we have to go through probate with your will to name your personal representative to take over. So the power of attorney and healthcare documents, the other advanced directives, are typically for your lifetime, and then at your death, they are invalid. Having a will or a trust means that probate is unnecessary. Having a will does not mean that probate is unnecessary. In fact, the probate process is the process of proving a will in court. The appointed personal representative is the only person who is authorized to manage the assets and debts of the estate during this process. So if a client comes into our office and says, I need a will because I don't want to have my estate go through probate, we have to tell them a will is the process of telling the court during probate what you want to happen to your assets. If you want to avoid probate, then we have to start talking about doing trusts. Trusts are the method that we can put in place to help avoid probate. But having a valid revocable living trust while it can avoid probate, only avoids probate for the assets that are owned by the trust. What that means is that after putting a trust into place, you have to what's called fund the trust. Funding the trust takes different forms depending on the type of asset that we are funding. For example, if we were funding your trust with your house, we have to deed the house to your trust. If we were funding a life insurance policy to your trust, then we have to change the beneficiary of that life insurance policy to the trust. If we wanted to fund the trust with your bank accounts, then we have to retitle your bank accounts into the name of the trust. That way, anything that is owned by the trust does not have to go through the probate process. Many people have set up living trusts, but have failed to place all or any of the relevant property into the trust. And so what that means is if you just have your trust done, but don't actually fund the trust, it means that your personal representative must still go through court to transfer the property through what's called a pour-over will. A pour-over will essentially states that I have created a trust, and if I have forgotten to put any assets into my trust during my lifetime, court, I'm asking that you put it into my trust so that I can follow the terms of that trust. Otherwise, we have to distribute all, if you don't have that pour-over will, otherwise you have to distribute all of the probate assets using the intestacy laws, or another will that you may have had in place that didn't leave everything else to the trust. We have another question. So Shanti asked that even if the bank accounts and life insurance policy has a named beneficiary at the time of death. So the answer is it depends. So it depends on who the beneficiary of those policies are going to be and what your goals for them are. So for example, you have your life insurance policy, and let's say it's $100,000, and you are leaving it to your spouse first, and then to your 3 children equally. Okay? You might be okay leaving everything to your spouse if you were the first one to pass away, because the spouse is going, and you have your trust. The spouse is going to put it into the bank account that's titled into the name of the trust, and so eventually it's going to get there anyway. But what happens when you're the second to die, and you now have children that can't manage money? Are they going to be able to take $33,000 all at once and not waste that away? If you want to put protections on that money from going to children that might not be able to manage money very well, then we would want it to go into the trust, and then the trust would state restrictions on how that money can be used for those children. Also, when we have minor children, minors cannot inherit until they are 18. So you have somebody that is under the age of 18. When we plan your estate, we are planning for something to happen to you before they turn 18. And so if you don't have the trust as your beneficiary, but have minor children as beneficiaries, then those assets must go through probate, and ultimately the court will put a trust in place for the children. So you have to decide if it's better for you to put the trust into place today with instructions that you leave, rather than to let the court make those decisions for you afterwards. And again, these documents are amendable. So over time, your children are over 18 now. They are all financially sound individuals. We can go in and amend the document to say that there are restrictions on when they can get their assets to no restrictions at the time of your death. Or, like we've been talking about on some of the other myths, some of the children are fine. They can get their assets right away. One of the other children, somebody else is not, and therefore you want to add more restrictions to that child's funds. And also what a trust can enable you to do when having your trust as the beneficiary of a life insurance policy is that if something happens to a beneficiary of yours, you don't have to keep going back and changing the beneficiary of that life insurance policy. In our trust, we would have laid out contingent beneficiaries. So what happens if if a child of yours passes before I do, well, if they have children, you might want it to go to them, your grandchildren. Okay, so the trust will already be stating that that's going to happen. And if they don't have children, maybe their portion gets split amongst your other children. So we can have these protections already built in. As far as the bank accounts go, having a pay on death beneficiary on a bank account is a way to go. What your beneficiary will typically have to do, though, in order to get access to those funds, is wait for your death certificate to be completed and come in, which usually takes a few days after you pass away to happen. Then they take it over to the bank. They provide the bank with a copy, and the bank is typically going to send the death certificate and probably some other forms that you filled out over to their attorneys to review and make sure that everything was good. Depending on the bank, this can be a relatively quick process, but it could also take months before your beneficiaries can have access to this money and these accounts. So by having your bank account titled in the name of your trustee immediately will have access to those bank accounts because the trust owns it and they are the trustee of that trust, and they will automatically be able to access that money. Does that answer your questions? Since probate is inevitable unless you have a trust, can we count on the court to follow through on what is written on the will? If not, why? Yes. So if your will has all of the provisions that you want to make of who is getting what and all the protections, generally speaking, the court will follow those. Yes, it is always possible that a beneficiary of yours can argue that you didn't mean to do it that way, that you didn't mean to give them so much money to this person, you meant to give more to me. And they can go through this fight. And yes, it will cost your beneficiaries money, but it will also eat into the money that you were leaving to them. One of the goals of putting a trust into place is hoping to avoid some of those unnecessary fights so that the most amount of your assets as possible can be passed to your loved ones and your beneficiaries. So those are the myths that we're going to go over for today. Does anybody have any other questions regarding any of the myths or estate planning in general? All right, so John asks, what about using a lawyer through a monthly subscription company? Are they good or similar issues to do it yourself over internet? It's all gonna depend on the lawyer subscription company, what they are doing for you, how much actual attorney interaction that you're going to have, and basically how much work are they actually doing for you. Are they going to be providing you just the general forms that they provide to everybody? Or are you going to be able to sit down with them or have a phone call with them and actually discuss everything that they need, and they're going to fill out all the paperwork and help you go through the signing process? So you can have some of the similar issues by using a company like that if they are not actually providing any real legal services to you, and they're really just providing the documents, like some of the document companies out there. So that you could have some of those issues. They might, depending on what you pay and the level of pay that you're paying for their programs, they may not actually want to spend the time, if that makes sense to you. So you're paying them a flat monthly rate of, let's say, $30 to $40. Is it worth their time to spend 2 to 3 hours with you, going over what you need, preparing the documents, going over the finished documents with you to make sure it is the way you want them to be, and then helping you sign them? Or are they just collecting a couple small details, putting it together the same way they put it together for everybody, and then sending it over to you, and you have to figure out how to sign it on your own? Then you're going to run into the same some of the same problems that you might have by doing it yourself with some of those document providers. Does anybody else have any more questions? Okay, I don't see any more questions coming in. So I want to thank everybody for joining us joining me today on this presentation. I hope you guys enjoyed it and you learned a little bit of something. Again, if you still have any questions, you can shoot me over an email at mrosenthal@rosenthalmeyer.com, and I'll be happy to answer some of your general questions. You can also see more about our practice areas at rosenthalmeyer.com. So that you can see the other types of practice areas we do, and also the extent of our estate planning practice. We have 3 locations, 2 in Florida and 1 in New York, for the convenience of our clients. But we do handle everything virtually now, but also we have the capabilities of doing so, even continuing, and have done so in the past through video chats and other types of software. Something to remember out there: if you're going to do your estate planning now, currently estate planning documents have to still be signed in person. There's a law that's supposed to come out in July to change that, but currently there's no knowledge on our part of whether they're going to move that up to assist us today. But documents like the will still have to, and the power of attorney still have to be signed in person. So our office is taking the necessary precautions and having our clients come in, you know, as safely as possible when needed. So as far as we know, we're still essential. So we're still going to be working for our clients' best interests. Again, thank you for spending the 45 minutes with me, learning about the estate planning myths, and I look forward to doing more of these over the next couple of weeks. So look out for some more Facebook messages and notes about upcoming presentations from us. All right, have a great day, everybody.